All right, so I guess we'll see if we get anyone here.
Hopefully we do. All right.
I just saw the notification go in on Facebook, so.
We'll see who tunes in. What'd you do for the game this morning? Did you eat anything good?
Not much.
It's too early.
All right, let's see. Oh, we have someone here. Hi.
Hi.
How is everybody? Good. We have Wilma, Margot, Rodrigo. All right. So I guess we'll start by introducing ourselves. So my name is Nathaly, and we are volunteers with Dreamers Together. We do a lot more on the AOS page. I'll let Marisol introduce herself.
I'm Marisol. We are all over the place right now. We moderate for Facebook, the AOS group. We're specifically tackling AOS questions today. And then we also do some stuff on other social media like Reddit. So if you guys are here from Reddit, hi guys. Yeah. Do you guys have any specific AOS questions, general FAQs, anything like that?
Or before the questions start coming in, just really quickly,
Yes.
like a quick disclaimer, guys, neither of us are lawyers. We're not paralegals, so none of the information is legal advice or should be taken as legal advice. We're just providing general information that is available to the public on USCIS website or publications of the INA code or the different government agencies that we deal with as DACA recipients.
Yes, as well as reiterating some experiences from other members that we see happen very often that we've kind of taken as, part of the process. That's pretty much it. So not legal advice. We're not lawyers. Quick refresher. We do want to cover something really quick because we did get a lot of new members in the adjustment of status group. We just want to clarify a couple of things. Adjustment of status is the ability to adjust here within the United States. It is not the same as consular process or getting a waiver. So it's completely different.
Yes, because we do see a lot of confusion within the DACA community, the immigration community in general, where we seem to think that adjustment of status or AOS, like you'll see commonly that we use AOS, just means some method of getting your green card. But adjustment of status or AOS, like Marisol said, is very, very specific to getting the whole process done within the United States. I'm just going to repeat that really quickly in Spanish in case we have any Spanish speakers watching our live. So específicamente queríamos dejar saber que el ajuste de estatus o AOS que le ponen es específicamente cuando usted puede obtener su residencia adentro de los Estados Unidos sin tener que viajar a su país natal. Ese otro proceso, cuando usted tiene que viajar a hacer su entrevista en su país natal, es proceso consular. Y es completamente diferente y separado para que no se me vayan a confundir mi gente, ¿ok? Okay, let's start. So,
Rodrigo.
yeah, we have a question from Rodrigo Jimenez. I have a couple of questions on Form I-485. As a DACA recipient for question 16, have you ever worked in the USA without authorization? So, Rodrigo, I'm going to answer you in English, but this pretty much goes for everyone, regardless of whether they're a DACA recipient or not. You do have to answer these questions on immigration forms truthfully. So if you've ever worked in the United States, either before you got DACA, which means you didn't have employment authorization, or in between your renewals, if your employment authorization had expired before your new one was granted, then you would put yes. Now, I do want to let you know, though, you don't have to worry because if you're eligible for AOS, that means you're being petitioned by a spouse that's a US citizen or by a child over 21 that's a US citizen. And that immediately waives, like it immediately forgives any unauthorized work in the US. So solo en español, Rodrigo pregunta sobre la pregunta 16 en el formulario I-485, que pregunta sobre trabajando en los Estados Unidos sin autorización. Uno siempre tiene que decir la verdad en los formularios de migración, es muy importante, pero no tiene que preocuparse mucho si trabajó sin autorización en los Estados Unidos. Si usted es elegible para AOS, significa que su patrocinador es su pareja que es ciudadana, o es su hijo mayor de 21 que es ciudadana o ciudadano. Y eso automáticamente le perdona cualquier trabajo que usted hizo, cualquier tiempo donde usted estuvo trabajando sin autorización legal. So thank you for that question, Rodrigo. I hope that helps or that answers. Let's see. Margo dice, gracias chicas por traducir. De nada, Margo, vamos a intentar lo más posible de hacer todo en los dos idiomas, pero si hablamos de algo y no lo traducimos, por favor, delos acuérdenos en los comentarios, solo avísenos, oh, se nos olvidó decir esto y esto en español. So we are going to try to do everything bilingual today for our community members. So let's see. Rodrigo's follow-up question. Do I need to explain that I did work without authorization? So, Rodrigo, yes, you can. I do know that the instructions on I-485 for that section specify that if you put yes, to please explain on the last page of the I-485 additional information. So you can. And then just to kind of give you an idea of what I've seen a lot of group members or personally a lot of my family members put down, it's really simple. You can just put, I did in fact work, in the United States without authorization because I needed to be able to provide for myself and my family. Wanted to cover basic necessities like food, housing, clothing. Like I said, if your petitioner is your spouse or your child, which is what you need to be eligible for AOS, it's not a big deal either way. They'll see that and they won't worry about it at all because they'll see who your petitioner is. Rodrigo pregunta si acaso tiene que explicar que trabajó sin autorización. Sí, esa sección del formulario 485 pide una explicación si es que usted marca sí. Y eso se hace en la última página del 485 y puede ser algo tan simple como escribir, sí, yo trabajé sin autorización porque necesitaba poder trabajar y tener ingresos para cuidarme de mí misma y de mi familia o para cubrir necesidades básicas como comida, casa, ropa. No es algo que se tiene que preocupar mucho porque su patrocinador va a ser su pareja o su hijo mayor de 21 que es ciudadano.
Y se lo va a perdonar. No tienen que dar tantos detalles, nada más lo que dijo Nathaly.
Exactly. So I'll let you take that one next one.
Let me see. My lawyer put on a form that I have never worked without authorization, but I have. Could that be a problem? What do you think, Nathaly?
So the great thing about these forms is that you are allowed to correct them at your interview. So, for example, once you get pulled into your interview, if you have an interview, you can correct them there. You can let the USCIS officer know, hey, I just realized my lawyer put down the wrong information for this question, and I'd like to correct it. I'd like to let you guys know that I did work without authorization. You can give them the same explanation we just previously mentioned, and the USCIS officer will have you sign off on the correction. At the end of the interview, they'll have you sign off on your I-485 form that you've corrected anything that needs to be corrected. So en español, Wilmer pregunta si acaso qué es lo que se puede hacer o si va a ser un problema dado que su abogado puso la información incorrecta en su formulario que no trabajó sin autorización, aunque él sí lo ha hecho. Le estoy avisando que no es un tremendo problema cuando uno va a la entrevista de su para su green card, para su residencia, usted puede hacer correcciones en la información que está en su formulario. So, si usted sabe de que algo estuvo puesto mal, le puede avisar a la oficial que le está haciendo la entrevista y le avisa si yo trabajé sin autorización, mi abogado puso la información incorrecta y ellos le hacen firmar al final una página en ese mismo formulario de que usted ha corregido todo lo que está en la información, todo lo que está en el formulario, perdón. All right.
I'll read this one, and if you could take over, please. It's a little bit.
Vanessa. Hi, Vanessa. All right.
A ver.
Reniel Ocampo?
Yeah, dice, thanks for doing this. You're so very welcome. Not sure if you have any info on this, but regarding the H-1B consular interview, if I use AP to come to my home country and get accepted during my interview, do I need to mention / use my AP at all when I come back? Okay, so the thing is, we've seen mixed comments from a lot of different attorneys. I believe I've seen one person use AP to be able to return with their or when they had their consular interview. We are not consular experts by any means. We always, unless you absolutely need to do it. In your case, I can see why, because of your employment petition. You don't need to mention AP at that point at all because you got accepted and you got your green card. So there's no need whatsoever. That just voided your DACA AP because you got your green card already. It would be
with H-1Bs, they'll have the visa. It's not a green card yet.
the visa to come back. Yeah.
Visa, yeah.
I think you'll be fine. It would be a little bit different if you had gotten denied. There's a gray area right there. If you plan on doing that, please seek legal advice for sure from an attorney, just to get different opinions. We've seen it happen once, and this was not recent, and this was just a comment made by one of our lawyers. So, definitely reach out to an attorney if you are planning on doing that. Dice Reniel que muchísimas gracias por hacer esto, y si no sabes si tenemos información sobre la entrevista consular para visas de trabajo. Si uso AP para regresar a mi país natal y me aceptan durante la entrevista consular, durante la entrevista consular, necesito que mencionar o usar mi documento de AP para regresar. No necesariamente si lo aceptan, porque va a tener la visa que lo va a dejar entrar, y en ese caso el permiso de AP ya no va a estar va a estar válido, pero no se va a tener que usar o nada de eso, porque ya va a tener el otro permiso para poder entrar. Ya si fuera de otro modo, si no lo aceptan o le niegan la visa en la entrevista, si planea usar o si quiere saber si es válido el AP, por favor consulten con un abogado. Lo hemos mirado una vez, pero nada más fue un comentario que hizo uno de los abogados que nosotros usamos. Pero es mejor, por favor, si van a hacer cualquier proceso consular, por favor usen un abogado. Please. Consulten con ellos y ver cuál es su opinión y qué es lo que ellos piensan que deberían hacer en el caso de que los nieguen en la entrevista. Pero si lo aceptan, usan la visa, regresen, no se preocupen por el AP.
So, el problema es que si le niegan, si le aceptan, ya tiene la visa en el pasaporte y usted usa esa visa para entrar. The problem is if your consular interview is denied and you don't get the visa, that's where it becomes tricky as to whether CBP will allow you to re-enter with the AP document. But if it gets accepted and you get your visa, that's what you're using to come in. So it's not a big worry at all. Okay, I think you have another one here, Fernando Herrera.
A ver, dice, yo quería hacer advanced parole, pero no tengo familia en México. Bueno, sí está mi mamá y mis hermanas, pero no me quieren ayudar. ¿Habrá otra manera por la cual yo pueda agarrar Advance Parole? Buena pregunta. Sí, hay
And
bastantes.
let me just add
Um,
in his follow-up.
He escuchado de procedimientos médicos, pero ¿cómo puedo agarrar una nota del doctor de México si no puedo salir? Muy buena pregunta. Si quiere obtener tratamiento médico o dental, primero tiene que obtener una cuota o estimado de aquí del país con todo el precio sin aseguranza o el precio completo del tratamiento. Y ya le recomendamos que usen Google, por favor. Google, o se meten a Google, el tratamiento que están buscando, ya sea dental o médico, más el área donde ustedes planean visitar, o personalmente mi recomendación sería a ciudades turísticas, ya que es más posible que les den los estimados de México ya quizás en inglés, o sean más dispuestos a dar el precio, ¿verdad? Pero es el caso de llamar. Ciertas clínicas no lo hacen, llamen a todas las que encuentren, por favor. No se rindan, sigan llamando. Um, Fernando asked, I wanted to do advanced parole, but I don't have family that is willing to help me. Is there another way that I can get advanced parole? I have heard of medical procedures being a valid reason, but how do I get a valid medical note from Mexico if I can't go out? In this case, Googling the location where you want to go to get the treatment, as well as the type of treatment that you're looking for, um, and then calling around those doctors that appear in the searches, like just calling as many clinics as you can. But also, before you do that, get an estimate estimate with out of pocket expenses from here in the US, from a doctor. That way, when you call the international doctor or dentist, you already have something to base your price on. Maybe you can scan it to them and they can translate what you have already into their prices, but it's just a matter of calling. I hope.
Y un tip es no mencionarle a los doctores o los dentistas de que usted lo está haciendo por razones de inmigración.
Mhm.
Porque a veces ellos escuchan eso y se cierran y no le quieren dar el estimado. So
Mhm.
usted solamente tiene que tomar el tiempo. O sea, no estamos diciendo que es algo fácil y va a pasar, va a ser, en la primera le va a salir el resultado, ¿verdad? A veces uno tiene que llamar a varios doctores, pero solamente usted llama, les dice, mira, estoy en Estados Unidos, no puedo ir para el estimado, pero me gustaría ir a hacerme este procedimiento. Tengo una copia de lo que necesito aquí, se la puedo enviar por email o por fax y me podrían, por favor, hacer un estimado. So just in English, a pro tip we usually give is do not mention to the doctors or the dentist that you're going to be using the estimate for immigration purposes or to get an AP document. Sometimes they hear that and they kind of get scared, and so they don't want to give you an estimate. It's not, we're not saying you're going to have success on the first try, the first doctor that you call. You do
Mhm.
need to put in the work, right? This is for you, so you need to put in the work. So just call around to doctors and let them know, hey, I'm located in the US, but I do plan to travel to Mexico and I want to get this or this procedure done. I have an estimate from the US. If it would be helpful, I can email it to you or fax it to you, and would you be able to give me an estimate of what it's going to cost in Mexico?
Mhm.
So that's kind of how you go about that one. Okay.
Have one for you. Hello,
This
ladies. I have a question. I was able to meet property guidelines for the previous year, but not for a total of 3. So, would I be able to sponsor my husband or do I need a joint sponsor? ¿Qué piensas?
So let's see here, Christy. What USCIS is really going to focus on is that your current income meets those poverty guidelines. So as long as your current income for this year meets those poverty guidelines, then you meet the base requirements. Now, because your other 3 years haven't met the poverty guidelines, there isn't a consistency that they like to see in your income level. So what you're going to want to do is just pad your I-864 with a little more evidence. And what you can do is, besides sending those 3 years of tax transcripts, I would personally also send 6 months of current pay stubs so that they can see that even though you didn't earn enough the last 3 years, this year from your pay stubs, they can see, oh, yeah, she's making more than enough to meet this poverty guideline. So then you should be fine. Another thing you can add in besides those 6 months of pay stubs, and it has to be 6 months, they don't like to see less than that. You can also add in an employment verification letter from your employer. They'll give you a letter on company letterhead, just saying, that you work for them, how long you work for them, what your position is, and how much you get paid. And so that also helps pad. So like I said, USCIS, they like to see, it's by law, you really only need to meet this current year, but they like to see consistency. So if your current last years don't show consistency, add that extra evidence to boost your I-864, so you don't have an RFE. Rapidito en español, Cristi pregunta si acaso va a necesitar un patrocinador adicional, dado a que eh, ella está ganando lo suficiente para los requisitos financieros para poder patrocinar a su esposo, pero los últimos 3 años no estaba ganando lo suficiente para esos requisitos financieros. Entonces, le estoy explicando a Cristi que UCIS, a ellos le importa lo que usted está ganando en el año actual, pero sí le gustan ver de que su ingreso es constante, o sea, que está ganando alrededor del mismo nivel los últimos 3 años también. Pero lo que uno puede hacer simplemente para comprobar que este año sí está ganando suficiente, aparte de los transcripciones de impuestos que usted manda del IRS, puede mandar 6 meses, los 6 meses recientes de colillas de cheques. O también puede enviar una carta de su empleador. Su empleador le puede hacer una carta de verificación en en un papel oficial de la compañía, y tiene que incluir información que usted está trabajando por ellos, desde cuando que trabaja con ellos, su posición en la compañía y cuánto le están pagando, cuál es su ingreso, el nivel de su ingreso. Eso le va a ayudar para que no le vayan a mandar un RF pidiendo más información o evidencia. So para todos, si sus últimos 3 años también no llegan a los requisitos financieros, mande esos 6 meses de colillas de cheque o envíe esa carta de su empleador para que no tenga problema, ¿ok? A ver, aquí tenemos María Angel Bautista. Question regarding combining income with petitioner and beneficiary to meet poverty guidelines. If the beneficiary income comes from a job and a business owner and the beneficiary is currently on FMLA, what kind of evidence would be sent to explain the change of income for those months, if any? Job. The beneficiary's income comes from a job and a business owner, and the beneficiary is currently on FMLA. Okay. Ooh, this is a tough one, Maria. Okay, so let's see here. What I'm understanding is the beneficiary's income comes from a job and business owner, and the beneficiary is currently on. You didn't mention where the petitioner's income is coming from.
Yeah.
But either way, because there's business income as well as, I'm assuming, what is a W-2 income from the job,
Mm-hmm.
and then family leave. So they don't really, USCIS isn't going to pay special attention to how your income fluctuated throughout the year. What they're going to pay attention to is your total annual income for this year. So you're going to want to make sure you really, it's going to take, it's not an easy number for you to figure out since you've had this kind of fluctuation happening, but try to like calculate what is the total income for this year for the petitioner and then separately for the beneficiary, and fill that information out in the I-864. And then you're going to want to send the tax transcripts. If your past 3 years of taxes show consistent income for both like if you've done joint taxes for both the beneficiary and the petitioner, I don't see you needing to send anything extra. because the tax transcripts will show consistency. And
Mm-hmm.
so if your numbers from this year match what you've made on the other 3 years, there's no like thing that's going to cause a red flag where USCIS is going to say, oh, we need extra information. Now, if this year is lower than the other 3 years, then you may want to send extra. Like, for example, since we're getting close to the end of the year, you may want to send in like any 1099s that you receive, W-2s. Since there's business income on there, you're going to want to send like bank account statements or a schedule of profit and loss for the business. So for your situation, you may need to send extra, but that's really only if there's like a huge amount of difference in income between the last 3 years and then this current year. Because again, there's nothing on the 864 where they're going to ask you a breakdown of month to month what you got in terms of income. They just want to know the total for the whole year. And remember, guys, that total is before taxes. So make sure that when you're writing that number down, it's before taxes and deductions are taking out from your income. Okay. Dalia, thank you for doing this. You're welcome, Dalia. We try to help out the community as much as we can. We try to be on the Facebook groups answering your guys' questions as they come in. Everyone pretty much has a full-time job. So sometimes during work hours, it's, we might be a little slow in responding and everything, but we try to do this so that we can help out, when we are available. That way you guys can feel empowered
Mm-hmm.
to send in your own applications. And if you do choose to go with a lawyer, that you feel empowered to have more of an active role in your application that they're preparing for you.
We might make these weekend streams a little bit more frequent, specifically for AOS. I know all of you guys are, work too, and this is a pretty big packet and it's very important. So I know that some people have specific questions that maybe need to get a little bit more information on. So weekend just seems to work a little bit better. So yeah, hopefully we start doing these a little bit more often.
And thank you for everyone who responded to the post that we did last week asking about whether you guys wanted a weekend live. That's why we're here, because of your responses. So thank you for participating. A ver. Rodrigo Jimenez, for question 25, have you ever been arrested, cited, charged, or detained? I got a driving without a license ticket, went to court, pleaded guilty, and paid a ticket. I should also explain this, right? Or is this a misdemeanor and shouldn't be reported? So, good question. That's one that we get super often on the Facebook groups. So pay attention to the wording of the question itself. It says, have you ever been arrested, cited, charged, or detained? That includes everything. So a ticket is a citation. If you pleaded guilty, you pleaded guilty to a charge of driving without a license. So you technically, under your specific situation, if I was driving without a license and got a ticket, I would have to answer yes to this question. Now, with traffic citations, traffic tickets, anything that's minor under $500 that you had to pay for that specific charge or ticket, you don't need to send any kind of paperwork like court documentation. You can, and if you have it, you should because it helps. But if you don't need to go out and look for it specifically, you can just put a brief explanation again on that last page of the 485, just saying exactly what you told us now, right? On this date, or you don't have to give the specific date. In May of 2012, I was pulled over and got a ticket for driving without a driver's license. I went to court and paid my ticket, and then and that was it. That's all the explanation that you need to give. Now, please, everyone, be careful. If your driving ticket, charge, or citation had anything to do with drugs or alcohol, that's different. Okay.
Mm-hmm.
It's no longer considered a simple traffic ticket. Um, and if your ticket also involved like bodily injury, like you injured someone, you hit someone or something like that, and you got a ticket for it, that also is not considered a simple traffic ticket. So for those, you do need to submit court dispositions and court documents. You can't just provide a brief explanation like these. Rapidito en español. Rodrigo pregunta sobre la pregunta 25 en el formulario I-485, que pregunta si acaso alguien ha sido arrestado, eh, recibido algún tipo de sí, how would you say cited?
Ticket.
Citation. Un ticket,
Ticket.
algún tipo de cargo o si ha sido detenido. Y él especifica que él tuvo un ticket por haber manejado sin licencia, que fue la corte y lo pagó. Entonces, yo siempre le digo a la gente si tiene que poner sí para esta pregunta, aunque sea un simple ticket de manejo, porque un ticket de manejo igual es un ticket. Cited o citation es un ticket. Y si usted lo pagó, técnicamente por ley usted dijo que sí, que aceptó la culpabilidad de un cargo. Un cargo, pues, aunque es un cargo menor, porque es algo de tráfico, de carros, no es algo grave, igual tiene que poner sí. Pero como es un ticket menor, simple, no hubo algo grave, no fue un ticket mayor de $500, con que no tenga que ver nada con alcohol o drogas y no tenga que ver nada con haber causado daños corporales a una persona, un individuo, entonces usted simplemente puede poner una explicación en la última página de la 485. Le estaba diciendo aquí a Rodrigo que él puede poner lo mismo que ha puesto acá, que tal fecha o tal mes de tal año yo estuve manejando, me paró un policía y me dio un ticket por haber manejado sin licencia. Yo fui a la corte y pagué el ticket en la corte y eso sería suficiente. Pero nuevamente, ojo, que eso es para los tickets de tráfico que son menores y que no tengan nada que ver con alcohol, drogas o daños corporales.
All right, I got this one
Ah,
for you. Let me you answer because this part I had the same question. Um,
okay.
if my wife, the USC petitioner, is a stay-at-home mom but worked 4 months out of the year in 2022 and the whole year in 2021, do I use her 2022 income or should I just use my income? I make well over the 125% for my household.
Okay. So Javier, it sounds like you are the beneficiary, right? Because you're saying your wife is the US citizen petitioner. So when you're the beneficiary, the only way to include your income is if you combine it with her income. So you can't fill out the I-864 on your own. It would still have to be filled out by your wife, but she can include your income on that specific section. I believe it is section, I
Let me
think it's
pull it up.
page 4. Um, if you guys give me a second, I can tell you which one it is. I believe it's page 4. Yeah, page 4, part 6, items number 8 through 10. So page 4, part 6, item numbers 8 through 10 is where she can put in your information as the beneficiary. As long as you are, well, I'm assuming this is me assuming that you're a DACA recipient and that you have a valid work authorization because you do need to have valid work authorization in order for your income as the beneficiary to be included. Um, So she would fill out all of her total income for this year, even though it's only been 4 months. She would add up those 4 months and put that in as her total income for this year. And then she would add in your total income in that section that I just specified, page 4, part 6, items number 8 through 10. But this is what you guys are going to have to do. You are going to have to send in additional supporting evidence. So she'll send her supporting evidence, her last 3 years of tax transcripts. And then if you guys haven't filed jointly, you'll also need to send at least 1 year of tax transcripts. And you're going to have to send 6 months of pay stubs and the letter from the employer. For your letter from employer, I would say add an extra little, when you're requesting it from your employer, I would just say, hey, mention to them if you could please put down something along the lines of that you intend to keep me employed permanently, full-time permanently, or for the foreseeable future. Because what immigration wants to see from you as a beneficiary when you're combining your income is that proof of income, so the 6 months of pay stubs, and that your employer intends to keep you employed. They want to see that you're going to have consistent employment in order for you to use your income. So I guess the answer to your question is you have to use both. You can't just use yours. The only way to use only yours is if her income was zero, but then you would still be using hers. You'd just be putting down that her income is zero. Um, Rapidito en español, Javier pregunta si acaso él usa el ingreso de su esposa, que es la ciudadana, o el ingreso de él, dado que la esposa es dama de casa con sus hijos y solo trabajó 4 años en este año del 2022, pero sí trabajó el año completo en 2021. Lo que le expliqué a Javier es de que mientras él tenga autorización de trabajar legalmente con permiso de trabajo debajo de DACA, por ejemplo, él puede usar su ingreso en combinación con la de su pareja. Eso no significa que él llenaría el formulario I-864, igual lo tiene que llenar su pareja, pero su esposa puede incluir la información de Javier y el ingreso de Javier en la página 4, parte 6, preguntas 8, 9, 10. Ahí es donde ella podría incluir la información de él. En el caso de ellos, ella trabajó 4 años, o para el ingreso de ella, ella pondría la información de lo que ganó en esos 4 meses, perdón, dije años, quería decir 4 meses, y pondría el ingreso total anual de Javier en esa sección que dije, ¿verdad? En la página 4, parte 6, preguntas 8, 9, 10. Ahora, Javier va a tener que incluir más información o evidencia con su I-864. Su pareja, su esposa tendría que obviamente siempre enviar las transcripciones de impuestos del IRS, pero él también tendría que enviar por lo menos un año de las transcripciones de ingreso. Él tendría que también enviar 6 meses de colillas de cheque y también la carta de empleador. Él no puede escoger uno de los tres, tiene que enviar los tres. Y para la carta de empleador, aparte de todo lo normal que tienen que incluir, sería en su mejor interés pedirle a su empleador que incluya algún tipo de frase diciendo que le van a estar dando ese trabajo permanente o que lo van a mantener empleado por el futuro que ellos vean que venga, ¿verdad? Porque UCIS quiere ver de que él va a tener un trabajo constante si es que él va a usar su ingreso para combinarlo con lo de su esposa. Ok, a ver acá. La próxima pregunta tenemos aquí a Jorge Flores. If DACA was acquired after the 19th birthday, what are the general steps to adjust through employment based? Any special considerations? Okay, Jorge, this one's unfortunately I hate when I have to give, not the best news. So first of all, with employment based, you cannot adjust through an employment-based petition unless you have 245I grandfathering. So we've said it several times with adjustment of status specifically. Remember, adjustment is only the process of getting that permanent residency within the US, not leaving the US. So with adjustment of status, in order to qualify, you do need to have an immediate relative that's a US citizen, which would be your spouse or your child that's over 21, unless you have 245I grandfathering. That's the only one that kind of offers um, um,
Protection.
more flexibility, yeah, more opportunities. Now with employment based, because you don't have an immediate relative that's a US citizen that's petitioning for you, then you can't adjust status unless you have, again, that same 245I grandfathering. So with employment based, without 245I, the only option that you have is consular processing. This is where it's going to become tricky for you, right? There are the unlawful presence bars that exist. Those are, what people say when they're banned from re-entering the U.S. for 3 years or 10 years, or permanently, depending on the bar that they trigger. So, with you have gotten DACA after your 19th birthday, that means at the very, very minimum, like let's say you got it one day after your 19th birthday, that means you've accumulated 366 days of unlawful presence. So, one entire year plus a day. Unfortunately, the unlawful presence bars are triggered when you leave the US after accumulating 180 days of unlawful presence, that is the 3-year bar, and 365 days of unlawful presence, that is the 10-year bar. So in your case, that would be the 10-year bar. Now, there are waivers that exist that you can apply for, but you have to have a qualifying relative for that waiver as well. So you
Mhm.
would have to have a parent or a spouse that is a permanent resident or a US citizen, which is kind of like redundant because if you had that, you wouldn't really be doing the employment sponsorship.
Mhm.
I can see if you have a permanent resident parent or US citizen parent, where you would be able to do this employment sponsorship instead of through them, because I know through them on certain countries it takes 7, 10 plus years, and employment sponsorship right now all of the visas are pretty much available like within 2 years or less. So that I can understand. If you have a parent that is a US citizen or is a permanent resident or a spouse that's a permanent resident and this employment route is faster for you, then that would make sense, but you do have to have one of those to be eligible to get that waiver. It's called a 601A waiver. We're not going to go too much into detail with it because again, we focus on adjustment of status. With the exception of employment based for DACA recipients, right? Because the only option is consular. For your case, it all depends on whether you have a qualifying relative if you can get that waiver. But you would, so I would suggest that you get an experienced lawyer for
For
your
sure.
case because that 601A waiver is not easy to get. It has a high approval rate, but most of them are submitted with a lawyer because there's a lot that goes into requesting that waiver.
Right.
So I guess long story short is you have to do consular process unless you have 245I. And then because you got DACA after 19, you will need a 601A waiver to finish your consular process. I cannot repeat this enough and say how important it is. None of our people should be going to a consular interview without a 601A waiver. If you've accumulated 180 days of unlawful presence, which means you got DACA after 18 and a half, or if you got DACA before 18 but you've missed, some of the renewals, you have 180 days. Do not leave the US without a 601A waiver for your consular interview. That's super important. That's when you guys hear all those news stories about people getting stuck in their home countries. Oh, they went to this interview because of they went to their green card interview in Ciudad Juárez y le negaron la entrevista y ahora está ahí por 10 años. That's why. It's
Mhm.
because they go out without a 601A waiver, either because they didn't know or because their lawyer was incompetent and didn't tell them about it, or their lawyer assumed that they didn't have unlawful presence and sent them without one. When you're doing consular, you have to be very, very, very detailed about how many days you have unlawful presence, and getting that waiver of unlawful presence if you're going to go. So just, be very careful. Definitely get a lawyer for this kind of process, for sure. Um, en español, rapidito. Perdón. Jorge dice de que él está tratando de hacer ajuste basado en una residencia de trabajo. Le hemos explicado de que lamentablemente cuando su patrocinador es su empleador, o sea, una visa de trabajo, digamos, una green card de trabajo, uno no puede hacer ajuste a lo menos que tenga la ley de 245I. Si no tiene la ley de 245I, la única manera es con su proceso consular. Nosotros no nos enfocamos en eso, pero sí una de las cosas que nos gusta siempre avisar a la gente, si usted ha acumulado más de 180 días de presencia ilegal en los Estados Unidos, necesita un perdón que se llama 601A para poder viajar a su país natal y completar su entrevista consular. Es muy importante. Ahí es cuando nosotros escuchamos de gente en las noticias de que van a buscar hacen su entrevista consular, independiente si es de familia o de trabajo, y le niegan la entrevista y luego no pueden regresar a los Estados Unidos. Y es por esa razón porque han salido sin pedir ese perdón. Ese perdón se pide adentro de los Estados Unidos, pero para Jorge le estamos dejando saber, sí, que para poder ser elegible para ese perdón, uno tiene que tener un familiar que sea ciudadano o residente, y ese familiar solo puede ser su padre, padres o su pareja, su esposo o esposa. No cuentan a los niños. So, si usted tiene un padre, madre que sea ciudadana o residente, o tiene su pareja que es ciudadano residente, obviamente si es su pareja ciudadana, no haga el proceso consular, por favor, haga AP y haga ajuste de estatus, mucho más
Mhm.
seguro. Pero si es su padre, su madre, que son ciudadanos o residentes, no hay otra opción que consular, y el de por empleo es más rápido que por familia. En ese caso, usted puede usar a su padre, su madre para conseguir el perdón, pero ir a hacer su proceso consular debajo de una aplicación de empleo. Espero que eso le ayude un poquito a Jorge. Avísenos si tiene un poco más de preguntas sobre eso, por favor. Creo que alguien está invitando a alguien al live. Muchas gracias por invitar a alguien al live para que consigan la información que necesitan. A ver.
When it asks how many times have you been married, is it total including current marriage or past marriages?
Total. So the question is, how many times have you been married? Take whatever questions you guys see on the 485 and the I-130. I know sometimes we like to think too much into it. USCIS is very direct. How many times have you been married? Answer it. If you were married once before and now you're married, you've been married a total of 2 times. So if you've gone to submitted court documents to get married twice, then you've been married twice. So María pregunta, cuando preguntan cuántas veces uno se ha casado, si acaso es el número total incluyendo el matrimonio actual o solamente los matrimonios en el pasado. So le digo a María que nosotros cometemos el error de pensar mucho sobre las preguntas que hace inmigración. Inmigración o UCIS es súper directo. So si ellos le están preguntando cuántas veces usted ha sido casada, es cuántas veces en total. Si usted ha sometido 3 veces a la corte para casarse, o sea, se ha casado 2 veces anteriormente y actualmente está casada, entonces serían 3 veces. Entonces, siempre ellos son bien directos en sus preguntas.
Dice Leonela, hi ladies, for AOS, do I need to send a criminal record for each country that I have, or each county that I have lived in?
That's easy, Leonela. If you have not had any criminal charges, arrests, citations, tickets, or anything like that, you don't need to send any criminal records. You really only need to send criminal records if you have a criminal record. Again, if you had any traffic citations that are under $500, have nothing to do with drug or alcohol, and have nothing to do with bodily injury, then you don't need to send any court documents. Just a brief explanation is good and sufficient. But if you did have anything to do with drug, alcohol, bodily injury, tickets over $500, or any other kind of criminal proceedings, you were arrested and it was dismissed, you were charged and they took it away, you were arrested and you did some type of probation program and then they expunged it, they took it off your record, doesn't matter. If you had a criminal history, arrest, citation, criminal proceeding, court proceedings, you need to submit a criminal record, and it has to be from wherever that record is held. So for example, I personally was arrested in DC. So I would have to go to the courts in DC and submit my court disposition from those DC arrests. If you got arrested in Texas, but you currently live in Oklahoma, then you would have to contact the Texas court system and ask them if they can send you your court dispositions. Usually they'll be able to send them to you by mail. So Leonela pregunta, bueno, dice, buenas tardes, Leonela. Dice, para el ajuste de estatus necesito enviar un récord criminal de cada condado en cual he vivido. Y la respuesta es relativamente simple en el dado caso que usted nunca ha tenido ningún récord criminal, cargos criminales, procedimiento criminal en la corte, no tiene que enviar nada. Si usted sí ha tenido algún ticket, cargo criminal o arresto en la corte, si es sobre $500 o tenía que ver con drogas o alcohol, si es de tráfico o cualquier otro tipo de arresto o procedimiento criminal, sí tiene que enviar los records de ese caso y lo tiene que obtener de la corte en cual ocurrió el delito o en la corte en cual usted tuvo que hacer el procedimiento. Si usted tiene cargos criminales por algún tipo de crimen severo o grave, sería buena idea obtener un abogado. Pero cosas menores como un ticket de velocidad, obviamente no tendría que hacer eso. Pero sí tiene que ir como le dije, a donde sea que la corte que tenga los records criminales es a donde usted tiene que ir. So, si la corte ocurrió en Texas y usted ahora vive en Oklahoma, tendría que comunicarse con la corte de Texas para que le envíen los documentos.
Dice Jorge, ¿quién les han aprobado de agosto? ¿De AP o de ajuste? Que de AP ahorita van en el mes de agosto, so puede ser de cualquier fecha. Veo que todavía hay personas que tienen su fecha de recibo los primeros de agosto y todavía no son aprobados, otros que todavía son de medio de agosto y todavía no, y ahorita son acumulados básicamente.
Sí.
So nada más hay que esperar.
La- exactamente. De AOS no conozco a nadie que sometió. Bueno, sí, conocemos algunos que sometieron en agosto y ya están aprobados, porque tenemos algunos miembros del grupo que el ajuste, yo no me explico, ¿verdad? Felicidades a ellos, pero no me explico, pero el proceso de ajuste de estatus de ellos lo enviaron y entre 2, 3, a algunos 6 o 7 meses ya tenían la tarjeta verde, la Green Card, la residencia aprobada. Creo que teníamos como 2 o 3 que se demoraron solo 2 meses, pero ellos todos son de California. Algo está pasando en la oficina de California de inmigración que están aprobando peticiones para residencia súper rápido. No supiera decirle, a lo mejor deberían entrenar a los que trabajan aquí en el de Baltimore.
A los de Texas, por favor.
Pero Jorge, avísenos si se refiere a AP o AOS, porfa, para darle más información. Okay, tenemos Dalia. Guys, you know how we can file online? Can we do one at a time? Example, send my 130. Dalia, sola para AOS, creo que me está refiriendo al AOS. Para el AOS, el único formulario que se puede llenar online es el I-130. Los otros formularios no se pueden llenar online. Y si usted está llenando un I-130, mi recomendación sería no hacerlo online porque puede hacer el 130 y todos los otros formularios de AOS conjuntos en un paquete. Donde los envía todos juntos a migración a UCIS a la misma vez y se procesan todos juntos. Y así no tiene que estar esperando, porque si quiere hacerlo mitad online y mitad por papel, tiene que hacer el de online primero, esperar que le envíen el recibo y luego incluir el recibo en los documentos, los otros formularios de AOS que va a tener que enviar por postal. So es un poquito, es como que si no le va a trabajar muy bien, en mi opinión, porque en vez de inmigración recibir un paquete, ellos van a tener una oficina trabajando en una cosa y luego el resto del paquete va a estar en otra oficina procesándose por otro servicio, centro de servicio. So, mi recomendación sería enviar todo junto, la verdad. In English, because I answered that in Spanish first. Dalia's asking if she can file each form one at a time, like her I-130 online. I think she's referring to AOS because of the I-130. So with the AOS process or forms, the only one that you can file online is the I-130. The other ones are not eligible to be filed online at this time with USCIS. I normally recommend that if you're going to be filing the I-130 and AOS in general, that you just send everything together in postal mail as one concurrently filed AOS packet. That way, the center that receives it is processing all of your forms together. Although you do, to be honest, have the choice to file the I-130 online, you would wait until you get a 797 receipt for that I-130, and then you would have to include that receipt in your AOS packet. I would steer away from doing that personally because USCIS is a government agency. They already have a tough time with like not losing documents or having people resend things that they sent correctly the first time. So I don't want to throw into the mix having one thing sent one office with electronically and having my other forms sent to another office separately and then them having to connect those. I don't want to make it more difficult or timely for the USCIS officers. My way of thinking or my method of doing AOS is to make it as easy and seamless for them as possible so they can issue things as quickly as possible. But that's just my personal preference.
The only exception for this, sorry, I mean to cut you off, Nat. The only exception would be if you are already doing like consular process and then you're switching to AOS, you would already have an approved I-130, so you don't have to refile again. Just make sure that it's active still. And you would have to send a copy of your approved I-130 with your I-485 plus supporting evidence. So yeah, that would be the only exception. Para agregar a lo que había dicho Natalie, la única excepción sería si ya estaban haciendo el proceso consular y decidieron cambiarlo para hacer AOS. Sería de que nada más tienen que mandar una copia de su I-130 ya aprobado, nada más la copia de la aprobación con el paquete de y 485 y más la evidencia, supporting evidence, con eso. So, la única manera que sería que recomendamos que dijéramos que está bien hacerlos separados y ya tienen el proceso consular ya anteriormente. So, that's it. Quería aclarar esa parte también para que no haya ninguna confusión. Nada más tienen que hacerse caso de que todavía está activa la 135. So, es importante.
Okay. Veamos la próxima.
A ver, dice Santiago, buenos días. Una pregunta, a mí me agarró migración. Me han dicho que puedo tener un problema en aplicar para AP porque me agarró migración cuando crucé con mis padres. ¿Ustedes creen que sea cierto y que tengo que pedir mi récord con migración si me agarran huellas? Para contestarle su pregunta, no tendrá ningún problema con AP. AP, ¿cómo le diré? Es una manera segura de que puede salir y regresar. A nadie le han negado la entrada por tener doble entrada registrada. So no tendrá ningún problema en viajar con AP. Ya sería un poquito diferente al momento de ajustar. Por favor, pidan sus récords para saber exactamente qué tienen. Inmigración y CBP a base de las entradas o la información que tenga sobre usted. Pero para pedir AP, viajar, no tendrán ningún problema. Just to reiterate what Santiago said, he is stating that immigration, he was caught by immigration, and he is wondering because he's been told by other people that he would have issues applying for AP. He is asking if it's true, if that would happen, and if I need to request my records from immigration because he got biometrics taken when that happened. As far as doing AP, there's no issue. Again, we're not lawyers. We're not giving legal advice. This is based off of information that we have received from Charles Cook directly. You would have no issue. No one's been denied entry for having a double entry on AP. So that part, there would be no issue. You can request your OBIM records for, what does that stand for again, Natalie? I forget.
OBIM, Office of Biometrics and Information Management.
Okay, thank you. You can request that FOIA to see exactly what biometrics were taken. There might be an issue adjusting status, but as far as AP goes, absolutely no issue.
Yeah, I agree. No real issue for that as well. And I just wanted to add on, just so you have a little more information as to why it's no issue. So there is a immigration court case called Aravelli Yeravelli, a matter of Aravelli Yeravelli. That court case pretty much set precedent that traveling on AP is not considered a departure in the United States. It's not considered a departure. It's when you travel on AP, as long as you come back during that period that they give you to travel, in USCIS's eyes, it's like you never left the United States. So that is why it's not necessarily dangerous to leave on AP, regardless of whether you've been here unlawfully, if you have a current deportation order or a final deportation order. The ones that are, the instances where you do have to be careful with AP is if you have open warrants or pending criminal charges or warrants.
Mm-hmm.
Those are the ones where you should probably not not
Oh,
leave on AP until those have been settled. So open, pending criminal charges or criminal warrants, those are the ones that are going to be an issue. But this situation is not an issue because of Arabelli Yerabelli.
yeah. Or
Um,
any drug and weapon charge, previous drug and weapon charges as well, based on what Charles Cook has said. So, yeah.
so, okay, so next one here.
Hi, Gloria.
¿Verdad? I can't see those.
Can't see those. Hi. Dice Carla, me acabo de casar y mi esposo es ciudadano, ya hice AP y quiero pedir mi FOIA, pero no sé cuál tengo que pedir.
Okay, I can handle this one a little bit. So, Carla, cuando se está preparando para hacer AOS, las razones por cual uno debería pedir una FOIA es para tener información sobre qué información tienen estas agencias de gobierno sobre usted. So, hay alguna gente que no necesita el FOIA necesariamente porque ellos se saben bien su historial. So, por ejemplo, le daría el ejemplo de alguien. Si alguien entró con visa a los Estados Unidos y se quedó y nunca ha salido. O sea, entraron en el, digamos, 2005, se quedaron pasado su fecha en la visa y han vivido aquí siempre, no han tenido cargos criminales ni nada así. Ellos no necesitan folla. ¿Por qué? Porque saben que entraron una vez y nunca han salido. Para mi gente que necesita folla son los que a lo mejor no están muy seguros sobre su historial de entrar y salir del país.
Ujú,
So, por ejemplo, si usted se vino a los Estados Unidos muy pequeña, cruzó cuando era niñita, chica, no se acuerda, no sabe bien el historial. Incluso si sus padres le dicen, no, nosotros, usted solo cruzó una vez, porque ellos le pidieron que se la cruzaran, ¿verdad? Igual es siempre buena idea que usted chequee sus follas porque uno nunca sabe. Cuando
ujú,
está cruzando a los Estados Unidos, especialmente menor de edad y lo está llevando otra persona, uno nunca realmente a veces se puede acordar o saber si acaso tuvo un intento a cruzar o si tuvo varios intentos a cruzar.
ujú.
Um, y tener un intento a cruzar no significa necesariamente de que usted es inelegible para la OS, todo depende de cómo inmigración o cómo realmente la patrulla fronteriza categorizó su entrada o su
Ujú,
intento a entrar. So, si usted entró cruzando y no está segura cuántas veces entró o si acaso se eran categorizadas como entradas o digamos entró, usted sabe que entró y salió, pero nunca la pillaron y quiere saber qué es lo que tiene inmigración de usted, porque la verdad que si ellos no saben es decisión de usted si le dice o no, ¿verdad?
yeah.
Pero es muy importante saber qué es lo que ellos saben, qué información tienen de usted. So, siempre en ese caso, las follas recomendadas son la folla de CPB, de Customs and Border Protection, y usted lo que debería pedir ahí es toda la información y sea general, no ponga información muy detallista, ¿verdad? Si yo estoy pidiendo una folla de CPB, yo voy a poner bien simple. Me gustaría saber todos los records de entradas y salidas de tal año a tal año, o en general de todas las que tenga usted debajo mi nombre y mi fecha de nacimiento. Y eso sería todo. Ahora, para el FOIA de OBIM, que es el que
Ujú,
comentó Marisol, esa es la Oficina de Biométricas, de Información Biométricas de los Estados Unidos. Esa es muy buena para saber si usted en algún tiempo le tomaron huellas. So, si usted cruzó la frontera y la pillaron, la agarraron y le tomaron huellas, y usted quiere estar segura si acaso realmente eso pasó o si no pasó, le va a someter un FOIA a OBIM. Para esa sí tiene que usted hacerse una carta de las huellas
ujú,
en como un cartón, hace las huellas, las escanea las huellas y la imagen del scan que usted hace lo tiene que someter con el FOIA en el sitio de web. Le voy a dar el sitio de web aquí, es www.securerelease, que se escribe securerelease.com. Ese es el sitio web oficial del Departamento de Homeland Security para poder someter follas con CBP y con OBIM. So usted va a ese sitio de web, se hace una cuenta, um, y puede someter las follas para esas dos agencias. La otra agencia donde sería buena idea someter un folla va a ser con UCIS si es acaso que usted no está segura lo que le ha, qué información usted le ha dado a UCIS en el pasado. Eso es importante para mi gente que han tenido un abogado o una organización que le ha sometido aplicaciones en el pasado y no está seguro qué información ellos le han dado a UCIS. La razón que es importante es porque, por ejemplo, para DACA, yo sé que teníamos que dar información sobre nuestra entrada a los Estados Unidos. So, si el abogado que le hizo la aplicación de DACA le comentó a inmigración de que usted entró 2 veces, entonces inmigración ya sabe, ¿verdad? UCIS ya tiene esa información y es importante que usted la sepa también. So, esas son las tres que yo recomiendo, CBP, OBIM y luego UCIS va a querer pedir una copia de todas las aplicaciones que se han metido en su nombre en el pasado. Y también UCIS tiene información limitada también sobre entradas y salidas, interacciones con la patrulla fronteriza. Creo que ellos tienen records, pero solo del 2002 y antes. So, de 2002 para presente no tienen, pero anteriormente el 2002 sí tienen. So, en todos esos tres lugares sería buena idea que someta una folla. So in English, Carla's asking, she's saying that she just got married and her husband is a US citizen. She's done AP, but she wants to do FOIAs so that she can be aware of what information these government agencies have on her. So we have mentioned that there's some people that don't necessarily need FOIAs. Like, for example, if you came on a visa, you overstayed, and you've never left since, you don't need a FOIA. You know that you came on a visa, you know when you came, and you know you stayed here ever since. But for example, if you came through the border, you entered without inspection, especially if you entered as a child and you're not aware how many times you tried to enter, if somebody was bringing you over, you don't know how many times you tried it, if you got caught, if you didn't get caught, you're not sure, you're not aware, and you want to know, right? You're going to submit FOIAs to CBP, which is Customs and Border Protection, and you want to keep it vague. You want to keep it as vague as possible, but also let them know directly what information you need. It's very important that you be direct with them. So, for example, what I would say is, my name is, Nathaly Uribe Robledo. This is my date of birth. I would like to know what records you have regarding entries, departures, and interactions with CPB under my name and my date of birth. And that's it. It's simple. You don't have to go into detail. You don't want to tell them, I want to know, do you have an entry from, through
Right. So
Texas on this specific date? Do not do that, guys. No, keep it vague, keep it general. I would like to know what records of entries, exits, and CPB interactions do you have under my name and my date of birth? And that's it. You're also going to want to submit a FOIA with OBIM, which is Office of Biometric Information Management. They're the ones that are going to have records if you were stopped by Border Patrol or CBP and they took your fingerprints. They're going to have that in their system. For that one, you do have to do a fingerprint card. Then you would scan it, save it as an image or a PDF, and you would upload it to your FOIA request. Both the CBP and the OBIM FOIAs are done online at www.securerelease.us. US, you create an account, you let them know what agency you're putting the FOIA under, and then you let them know what you need. You have to be direct and let them know what information you need, but also do not be very specific. The last one that you're going to want to do is a FOIA with USCIS, especially if your past petitions have been submitted by a lawyer or an organization and you're
mhm.
not too sure about what information was already disclosed. You want to know what information was disclosed. For us DACA recipients, I know the initial DACA asked a lot about our entries. So if the lawyer who helped you in the past or the organization helped you in the past incidentally disclose that you do have two entries into the US and they're more than a year apart, that's something that you're going to want to know because you're not going to want to do certain things if they have that information already. So,
Mhm.
like I said, those three places are going to be CBP, OBIM, and USCIS. There's one other place I forgot. You can submit, it's not technically, it's not a FOIA, it's called an individual summary or they call it in colloquial terms a rap sheet. You can get that from the FBI. That one also requires fingerprints, but you
Mhm.
really only need that if you're not too sure about your criminal history. So en español se me olvidó mencionar que sí hay otro que puede pedir con el FBI. No es realmente un FOIA, se llama un sumario individual, donde usted le está pidiendo toda la información que el FBI tenga sobre cargos criminales debajo de su nombre. Se también trabaja con huellas, le tendría que enviar una huellas al FBI, pero realmente solo lo necesita si no está muy seguro de su historial criminal. Ok, la próxima. A ver, tenemos Jimena. You guys are the best. Thank you, Jimena. We appreciate you. We see you on Reddit, girl. And congratulations, Jimena, for that insanely quick AOS
Yes.
approval. You're gonna be one of our VIP on our records of how fast that approval was.
I have
So
a lot of
congrats.
screenshots about your posts, and thank you so much for being so detailed with your posts. Honestly, it helps so many. Thank you for making those infographics about it too.
Yes.
It's so helpful. Um, you're the best.
Yes, Jimena, you're amazing. The infographic you posted today, it was amazing. I saw it and I was like, yes, like this includes the fees for USCIS. It includes all these other medical exam fees. She even included like, printing and copying fees. That is a great help to our community so that they can really, financially plan for the cost of AOS. So we really appreciate it. You're amazing. And again, congratulations. We're so happy for you over here at D2G. A ver.
Let's see.
You
For
want to
question
read that one?
70. Yeah, I got you.
Okay.
For question 70, dice Rodrigo, have you ever been excluded, deported, or removed from the USA? I came at age 10, was detained at the border 4 times, and returned to Mexico. I was able to get DACA, AP, and I got my FOIA, and did not show up in my record. Do I need to disclose that I was detained at the border?
Okay, this is gonna go back to the question that we just answered with the FOIA. So Rodrigo, I highly recommend that you do not submit an AOS packet until you've gotten. I know that you say you got your FOIA. I hope that you got your FOIA from CBP and OBIM. But if you only got your USCIS FOIA, I highly recommend that you get that CBP and OBIM FOIA before you move forward with AOS. Um, and don't be too worried, right? This is something that I recently discussed, I think, within our group, within the volunteer group at D2G. So it's it's a little tricky in terms of how a border patrol officer categorizes your detention when you were crossing over. That's why I was saying crossing attempts and crossing entries are separate things. So you could have attempted to enter the United States 4 times and you got turnaround, or they call them sometimes throwbacks, 4 times. Those are not considered exclusions, deportations, or removals. Those are considered voluntary returns. That's not the same thing as a voluntary departure. Please pay attention to the verbiage that I'm using. It's called a voluntary return. A voluntary return is basically the equivalent of you coming up to the border and right before you go over that line, a CPP or a Border Patrol officer sees you, stops you, and says, turn around and head back. And so when they tell you to do that turnaround and head back, you never officially entered the United States. You tried to, but you didn't. And so it becomes a little more delicate as to whether you have multiple entries, which unfortunately people think multiple entries always equals permanent bar. It doesn't always equal, but it does mean that you need to be more detailed and find out more information. I would say, again, not a lawyer, not legal advice. I personally, in this situation, would get FOIAs from OBIM, from CBP, if your entries before 2002 from USCIS, and go over them with a fine tooth comb, you're going to want to see what the Border Patrol officer categorized your return as. If it says voluntary return, that means you never officially entered the United States. That means you tried 4 times, but didn't cross that line. And on that 5th time, you must have came through because you're here, right? So technically, you have one unlawful entry into the United States, and you would be okay. Now, if you, in any of those 4 previous attempts, um, you got something called an expedited removal, that is considered a removal. So that is the same as you having been deported and then re-entered when you came in through the border the 2nd time, if they have records of that. Again, not lawyers. I can't advise you one way or the other, but if you know you have 2 entries and they don't know you have 2 entries, totally up to you as to whether you disclose that or not. Um, I know that they specifically ask about your most recent entry, so there's that going for you. But definitely, like I said, recommend that CBP, OBIM, FOIA, and look for that voluntary return labeling. If you see that on the other 4, those are not considered entries, so you should be good. En español, Rodrigo pregunta sobre la pregunta 70, que es si acaso uno ha sido excluido, deportado o removido de los Estados Unidos. Dice que cuando él tenía 10, lo detuvieron 4 veces en la frontera, y luego se tuvo que regresar a México esas 4 veces. Obviamente, Rodrigo eventualmente cruzó porque está aquí, ¿verdad? Él pudo agarrar DACA y AP, y obtenió su FOIA y no salía en su historial. No estoy segura qué tipo de FOIA Rodrigo consiguió, pero yo le recomendaría agarrar la FOIA de CPP, de OBIM que recién platicamos, y también el de UCI si es que no lo ha agarrado. No necesariamente esos 4 intentos a entrar a los Estados Unidos son considerados entradas. Todo depende de cómo el oficial de la patrulla fronteriza categorizó ese intento. Hay muchas veces que mi gente no sabe de que cuando los paran en la frontera y usted técnicamente no ha entrado oficialmente a los Estados Unidos, ellos le toman las huellas y rapidito le dicen, ok, dese vuelta y regresa a México, de regreso a México. Eso le dicen en inglés turnarounds o turnbacks. O throwbacks, y esos oficialmente se llaman voluntary return. Um, en inglés, le voy a decir la palabra en inglés porque en sus papeleos que obtenga con ese FOIA va a salir en inglés. Voluntary return, voluntary return. Si sus papeles dicen eso, eso no fue una entrada oficial a los Estados Unidos. Entonces no se me vaya a espantar pensando de que tiene 4 entradas. Los voluntary returns no son entradas y no afectan en términos de las leyes de entrada de la barra permanente. Pero esto sí significa que usted definitivamente necesita sus follas y debería revisarlos con bastante cuidado y detalle. Yo siempre le digo a mi gente de nuestros grupos de Facebook, si obtiene sus follas y no está muy seguro, no se siente cómodo interpretar la folla solitos, publique una foto de su folla en el grupo con su información privada bloqueada y nosotros le ayudamos. O si no se siente cómodo hacer eso, escanee la copia de los follas y envíenos a nuestro email support @dreamerstogether.com .org, perdón, support@dreamerstogether.org, y con eso nosotros le podemos revisar la folla. Nuevamente no somos abogados, pero le podemos tratar de explicar qué es lo que le dice su folla. Espero que eso le ayude un poquito, Rodrigo. Definitivamente obtenga eso antes de someter su AOS. A ver, aquí Rodrigo pregunta sobre el formulario 864. Rodrigo dice, I have 40 working credits. What form should I send out? I-864 or I-864W? Okay, Rodrigo. So for this one, I'm going to be very honest. USCIS is giving people a hard time with the 864W form. So I would say the following. If your sponsor makes enough on their own, like their own income to meet the poverty guidelines for 864, just do that one. Why? Because that's the more traditional form, and that's what USCIS is most used to seeing. It's going to help you a little bit understand why if I explain to you how USCIS works. So when an application gets sent into USCIS, USCIS has these employees. I call them pre-screeners. I don't know what their official job title is, but I call them USCIS pre-screeners. So these people, essentially, they're the ones that open up your packet and they review everything for completeness. So they want to make sure that all the forms and all the pages of each form are there. And then they kind of categorize and scan your copies into USCIS's electronic system called ELIS. So unfortunately, those people sometimes are not as educated as we are about different forms and how you qualify for different forms. So I've seen a few people who do have their 40 credits, and they get an RFE anyway for it. So I have two options for you. If your spouse meets the poverty guidelines, submit the 864, keep it simple, just go down that route. If your spouse doesn't, and you do need to rely on your 40 working credits, you're gonna need to do one of two. You're gonna have to do two things, in my opinion. The first thing is you're gonna want to pull your Social Security earning statement from the Social Security website. You're gonna look on page 2 of that document, and there's gonna be a table, like a chart. You need to be able to count 10 years on that chart. So we are currently in 2012, which means you're going to have to count 10 years, which is 2012 to 2021. So 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Yes, that's 10 years. So from 2012 to 2021, you have to see each of those years in the chart. You should see, literally 2012, 2013, 2014. You need to see all of them on the chart, and you need to see enough income for each of the years on there to have earned the 4 credits per year. So if you don't have the 10 years on the chart, even though technically Social Security Administration says you have 40 credits, for USCIS definitions, you don't. So you wouldn't be eligible for the 864. But if you do have them on there, this is my personal advisement, not legal advice. This is just my personal opinion. You're going to send the 864W with the earning statement. I would send a separate letter with the 864 explaining that you have met your 40 working credits by showing years 2012 through 2021 on your earning statement, and that qualifies you for the 864W based on the exemption for 40 working credits. Sometimes I think if they see the form with that paper, then they'll say, oh, this person does qualify for this. I just wasn't aware. And then they'll let your form go through to the actual USCIS officer that's going to adjudicate your case. So that would be my personal opinion. Rodrigo dice que tiene los 40 créditos, a donde él técnicamente es elegible para someter el formulario 864W, que no requiere que su pareja o su patrocinador demuestre que tiene suficientemente ingreso para el AOS. A Rodrigo, mi primera recomendación personal es que si su pareja o su patrocinador sí gana lo suficiente para los requisitos financieros, olvídese del 864W, solo envíe el normal con los comprobantes y hágale el proceso más fácil, porque los empleados de UCIS a veces no tienen toda la información aunque trabajan ahí. Ellos a veces son los que abren, categorizan y escanean los documentos y no necesariamente tienen todo el conocimiento de los diferentes formularios. So, a veces hemos visto gente que han recibido RFE, y más información y más evidencia porque creen que no califican. Si es que usted ha chequeado y sí realmente califica y puede ver los 10 años en el chart que se encuentra en la página 2 del estado de earnings del Social Security Administration, Administración de Seguros Sociales. Entonces ahí sí, y si usted quiere, intente de enviar el 864W si es que su patrocinador no gana suficiente, pero mi recomendación personal sería, aparte de enviar el earning statement de Social Security, también envíe una carta como un tipo de explicación sobre cómo usted califica para la 864W. Y a lo mejor de esa manera la persona que está leyendo, abriendo los paquetes, categorizando y escaneando, usted le eduque un poquito con esa carta y no vayan automáticamente pensar de que usted no califica para ese formulario y le envíen un RFE. Eso sería mi recomendación personal. Ok.
She said, Jocelyn, good afternoon, just joined. What is considered two unlawful entries? On my DACA application, we listed initial entry in 1995 and last entry in 2001. Would that affect me when doing AOS?
Possibly. So this is what I want you guys to take home from this live when it comes to permanent bar, unlawful entries, unlawful presence. The permanent bar isn't really decided about how many unlawful entries you have. It's actually decided about how much time you spent in the US with unlawful presence and then left and re-entered, if that makes sense. The reason why it's not necessarily two unlawful entries is because if you have, like, for example, if you came to the US on a visa, which is a lawful entry, and you stayed and then you left, but when you came back in the second time, you came in unlawfully, you could still get that permanent bar, even though you only have one unlawful entry. What really determines it, like I said, is the amount of time that you spent in the US unlawfully before leaving. So in your case, Jocelyn, what's really going to matter is how much time you were in the US before you left between those years. Now, the unlawful presence bars, they didn't come into existence until April 1st of 1997. So that is when you would start counting your unlawful presence. Even if you were a minor, okay, guys, permanent bar still counts time as a minor. So if you left the US, Jocelyn, before April 1st of 1998, that means you would not have accumulated the entire year that is needed in order to trigger that permanent bar. So if you left before April 1st of 1998, you did not accumulate enough time to have triggered the permanent bar when you entered again in 2001. If you did stay past April 1st of 1998, that means you do have the 365 days of unlawful presence, which means that when you left and then re-entered in 2001, you did trigger the permanent bar, which will affect your eligibility for AOS. You cannot do AOS. I mean, you can apply, but your AOS will be denied for triggering that permanent bar. So it all depends on when you left. I'm not sure if you explained in your DACA application when you left or if there's any records of when you left. But again, just to reiterate those dates, if you left before April 1st of 1998, you didn't accumulate enough time to trigger the bar. If you left afterwards, you did. Um, do with that information
What you want.
whatever you think is best. Yeah. Jocelyn pregunta, ¿qué es considerado dos entradas ilegales? Que en su aplicación de DACA inicial habían puesto que entró en el 95 y que luego entró nuevamente en el 2001. Si acaso eso va a afectar su proceso de AOS. Lo que le estaba explicando a Jocelyn es que una de las cosas que me gustaría que todos entiendan y se acuerden de este live es que la barra permanente o lo que la gente se preocupa cuando dicen dos entradas ilegales es la barra permanente. La vara permanente realmente no se enfoca en los números de entradas ilegales que usted tiene que ver con cuánta tiempo estuvo sin estatus legal en los Estados Unidos antes de salir de los Estados Unidos. Le voy a dar un ejemplo rapidito. Si alguien entró con visa legal y se quedó viviendo aquí, digamos, 2 años y luego se fue y volvió, aunque ellos solo tienen, y esa segunda vez que entraron, nuevamente entraron ilegal, aunque esa segunda entrada fue la única que fue ilegal, la primera sí fue legal, igual ellos activaron la vara permanente porque vivieron aquí más de un año sin estatus legal y se fueron y entraron ilegalmente. Lo que realmente importa es cuánto tiempo usted ha acumulado viviendo en los Estados Unidos sin estatus legal y que eso ocurra, que usted acumule ese, se vaya y entre ilegal. Eso es lo que realmente causa la barra permanente. En el caso de Jocelyn, ella dice que entró en el 95 y luego entró otra vez en el 2001. Las barras de presencia ilegal no fueron ley hasta el 1 de abril del 97. Lo que eso significa es que si ella se fue de los Estados Unidos antes del 1 de abril del 98, no alcanzó a acumular los 365 días necesarios antes de salir y entrar nuevamente en el 2001. Si es que ella quedó viviendo aquí pasado el 1 de abril del 98, sí acumuló ese tiempo. Entonces, cuando ella se fue durante esos años, se fue y regresó, técnicamente sí activó la barra permanente. Ahora, yo no sé si en la aplicación de DACA ella especificó cuándo se fue del país entre medio de esas dos fechas. Yo no sé si esa es información que ella ya le dio a inmigración o a UCIS, pero esa es la fecha clave, 1 de abril del 98. Si ella se fue antes, digamos, si se fue el 31 de marzo del 98, cuando ella se fue, no alcanzó a acumular esos días ilegales para poder activar la barra permanente, y estaría bien. Entonces, que Jocelyn haga con esa información lo que ella crea que sea mejor, pero definitivamente va a querer saber si acaso ella ya le ha avisado a UCIS cuál es la fecha que ella salió de los Estados Unidos entre los años 95 y 2001.
Dice Marisela, quiero arreglar por mi papá ciudadano, tengo la entrada legal, podré arreglar.
You want to take this one?
I don't want to mislead.
Okay.
I'll let you take it over.
You're fine. Marisela, lamentablemente, un padre ciudadano no es un familiar inmediato que le haga elegible para AOS. Para poder hacer AOS, usted tiene que tener una pareja ciudadana, esposo o esposa ciudadana, o hijos mayores de 21 que son ciudadanos. Los padres ciudadanos lamentablemente no son considerados familiares inmediatos para lo que es AOS. Tendría que usted hacer el proceso consular en este tipo de situación, a lo menos que usted tenga la protección de la ley 245I. Ahora, como usted está mencionando que su padre es un ciudadano, pregúntele o sea, si él consiguió su residencia por una petición que se hizo por él antes del 30 de abril del 2001, es posible que usted como hija esté protegido debajo de esa misma ley de la 245I. No tengo más información sobre su situación, ¿verdad? Porque la falta de detalle, pero averigüe. Si uno de sus padres eh, um, alguien metió petición por ellos antes del 30 de abril del 2001, es posible que usted se pueda agarrar de esa ley 245I y ahí sí va a poder hacer un ajuste de estatus. So, haga eso primero, cheque eso primero. So in English, Marisela's asking whether she can adjust status through her father, who is a U.S. citizen. And unfortunately, for AOS purposes, the only immediate relatives that count that are US citizens are going to be your spouse or your child over 21. Parents are not considered immediate relatives for USCIS and AOS purposes. So she would have to undergo consular processing unless she was grandfathered under 245I. That's the only one that makes an exception to that rule. Now, because her father is a citizen, it's possible that he could have become a citizen because back in 2001, somebody petitioned for him. So I did let her know she should, ask her parents how it is that they became residents to begin with. So if either of her parents was petitioned for a family member or by an employer before or by April 30th of 2001, it's possible that she's grandfathered as a derivative. And in that case, she would be able to adjust. But that is the only exception.
Marisela también, como está preguntando en YouTube, ¿usted está en el grupo de nosotros de Facebook? Es para ajuste es AOS dash
Guion.
Dreamers Together, or guión, yeah, Dreamers Together en Facebook. Por favor, únase a nuestro grupo y después de que ya averigüe los detalles, ponga su pregunta, haga una publicación con poquito más detalle para poder avisarles si sí o no puede arreglar. Porque, pues sí, como no tenemos mucho detalle sobre su situación, no le podemos dar un sí o no definitivo. So por favor, únase al grupo, averigüe y nos avisa. Ahí le podemos ayudar un poquito mejor. I was telling Maricela, since she's asking from YouTube, to make sure that she joins our group. That way, when she knows a little bit more details about her situation, if she is covered or not, or once she knows a little bit more, we would be able to answer her question a little bit more clearly, give her a little bit more of a definitive answer if she were to join the group after or when she knows a little bit more. If she can make a post, we can help a little bit further. So.
Okay, let's see here. We have
Yeah.
Leroy.
Yeah. Dice, hello there. I have a question. My AOS package arrived at the Elgin lockbox in November 16. It was signed that it was received, but I haven't received notice of receipt. It's been 1 month now. Is that normal? Please, I need your opinion on this. I am confused. So, good?
Good question. I think I'm not sure if this is the same gentleman that I've provided a little bit more information within the Facebook group, but it doesn't matter either way. Leroy, a 1 month without any notice is getting to be on that borderline of not normal
Yeah.
processing for USCIS. I do know it's holiday season, so they're a little delayed on stuff, but the average that we see is between 1 and 3 weeks for it taking to have some type of notice either in your email or in your postal mailbox.
Mm.
So I would definitely suggest that you contact USCIS as soon as possible. They should be able to investigate why it was signed for and hasn't been processed as received. If you don't get a definitive answer from them, you can reach out to the I can never pronounce this word. Ombudsman, ombudsman for USCIS. It's basically this office that all they do is kind of they're the middleman in terms of service requests. There's certain things that they can help with and certain things they can't. This is definitely one of the things that they can get on top of. The other thing you can also do is reach out to your local representative, congressman or senator. They can also actually contact USCIS on your behalf
Mm-hmm.
and say, hey, this person submitted their package over a month ago. They have tracking and proof that someone signed for it at your lockbox, but you guys haven't sent them a receipt, and this is unacceptable. So
Um,
in your case, I would go through all those avenues. I would contact USCIS, I would contact the ombudsman, and I would also contact my congressman or
yeah.
congresswoman.
I want to add to that too. This would be if you filed on your own. If you filed with an attorney or
Oh
with
yeah,
a legal consultant or really like if someone else filled out your paperwork for you, contact them as well because it's very, I want to say 9 out of 10 times they make it so all correspondence about any case towards USCIS gets delivered to their offices or to their address. So if you filed with someone else, make sure that you contact them and have them look through their stuff. They might have your receipt. They might not have sent page G1145 where it would notify you directly, and it may have been, so they're the ones that get notified about everything else. So definitely if you used someone else's services or hired someone to fill this out for you, reach out to them as well to see if they have received anything, because yes, we're talking a little over a month now.
yeah.
Dice Leroy que mandó su paquete al did we answer this in Spanish? I don't think so, right? Dice Leroy que mandó su paquete y fue recibido y firmado en la oficina en Illinois, el 16 de noviembre. No ha recibido ningún recibo ni ninguna información sobre de que haya sido recibido o escaneado en las oficinas de UCIS. Ya en este punto va más de un mes. Lo normal típicamente es de 10 días hábiles o 2 semanas, 2 a 3 semanas completas. Ahorita ya está pasado de tiempo. Puede contactar a su congresista o senador, también al ombudsman, no sé cómo se diga en español, pero es como una persona que puedan contactar de UCIS, pero también es súper importante. Si usan el servicio de alguien más, ya sea de un abogado, una organización o un representante legal, por favor, nunca notarios. Si usan a alguien que les ha llenado los documentos, por favor comuníquense con ellos también, porque 10 o 9 de 10 veces es probable de que ellos llenaron la información para que les llegara directamente cualquier correspondencia sobre su caso a las oficinas o a la dirección de ellos. So, por favor, si usan el servicio de alguien más, asegúrense de que hayan llenado la información o el paquete para que les llegue directamente a ustedes, o si lo llenaron para que les llegara a la dirección de ellos, que se aseguren de que les den su correspondencia. Legalmente todos estos documentos son suyos y que se los den y les avisen a tiempo, por favor.
I'm gonna try to run through these questions as quickly as possible.
Yeah.
A few of them are quick answers, so let's see. Jorge's question 2: if DACA was acquired after the 19th birthday and if AP was approved and leave the country, will this trigger a 10-year ban? Can the immigration officer deny AP due to unlawful presence? Quick answer: no. Will not trigger the 10-year ban. Officer cannot deny your AP entry based on unlawful presence. The reason goes back to what we mentioned before, a matter of Arabelli Yerabelli with immigration courts. Immigration determined that traveling on AP is not considered a departure. So it's like you're not leaving the US. As long as you travel within the time period designated on your AP document, then it is not considered as you leaving or departing the US. So it would not trigger a 10-year ban. So anybody that has been here many years and has accumulated unlawful presence and leaves on AP and then comes back, that doesn't trigger any sort of ban. It's almost as if you never left. Rapidito en español, Jorge pregunta si acaso él obtenió DACA después de su cumpleaños número 19. Obviamente eso significa que acumuló por lo menos un año de presencia ilegal y luego usó AP para salir del país, si acaso eso activa la barra de 10 años, si acaso el oficial de inmigración le puede negar la entrada de AP dado a su presencia ilegal y la respuesta es un simple no. Dado a la corte el caso de inmigración de Arabelli y Yerabelli, que es un caso que inmigración decidió dejar claro que salir con AP no es considerado una salida oficial para inmigración. So, no activaría la barra permanente o la barra de 10 años y aparte de eso, el oficial no puede simplemente negarle la entrada por tener presencia ilegal. Eso no es una razón por cual ellos le pueden negar la entrada. Marisela. Ok, creo que eso es una pregunta duplicada porque creo que también es la otra Marisela de YouTube. Donde le avisamos que compadre ciudadano, aunque tenga la entrada legal, solo para avisarlo otra vez, no es elegible para AOS. Pero sí cheque eso de la 245I, porfa. How do we know when we should seek legal assistance with a lawyer rather than filing on our own? I filed AP through DACA and live in Texas. I already have the I-94. We cannot advise you as to whether you should or should not use a lawyer. That is your own personal preference to make. I will say that straightforward AOS cases are relatively easy. They just require time and dedication. And by straightforward, I mean you do not have any any major criminal charges. Like outside of traffic citations, you have nothing else criminal, unless nothing major criminal charges, nothing major. And then also you don't have like a history of staying, living here and then leaving the US and then coming back. And no deportation orders. If you have a deportation order pending or closed, that would be a good reason to seek a legal assistance when it comes to applying for AOS. Um, we have some great, amazing lawyers that have been vetted by Dreamers Together. There's Charles Cuck from Cuck and Baxter. Um, his website is immigration.net. There's also Gloria Cardenas, also known as the Immigration Queen. Her website, I believe, is familiaamerica.com, I believe it is. Those are two great lawyers that you can reach out to. They take cases all over the United States, so it doesn't matter where you live. I see you're in Texas, but you can reach out to them for a legal consult and let them know of your case, and then see if they'll take that on. But again, um, personally, straightforward case, no criminal charges, no multiple illegal entries after staying here for a year. Um, nothing major like that, no open deportation cases. Generally speaking, it's fairly easy. It's just about reading the forms, reading the instructions, filling it out. If you have questions, that's why we have this Facebook group. So if you
Yeah.
want to try it on your own and you get stuck, just let us know. If you want some ideas as to what supporting evidence you can send in, let us know. We'll be happy to help.
And also, we do recommend seeking legal advice too. If you request your FOIA and there's information on there that you know for a fact is not correct, like if you know for a fact that you only came here once, but it shows 10 entries and departures and all of that. So if there's information that should not be on there and you know for a fact that it shouldn't, and you need to basically fight that information, please hire an attorney as well. We just had someone not too long
That, that
ago
wasn't that wasn't
that
their FOIA though. It was the travel history on
it
the
was the travel
I-94
thing,
website.
right? On I-94.
Yeah,
Yeah.
but that one doesn't count, guys. That's not
Yeah.
an official um legal record.
Yeah, but if it's
Um,
like on your actual, like, if
FOIA,
it's,
yeah,
yeah, if it's on your FOIA,
for sure.
definitely fight that. Um,
Yes.
También sí, um, dice Josie que cómo saber cuándo recomendamos o cuándo deberían hablar con un abogado y obtener información legal con un abogado para hacer AOS. Josie dice que ya tiene AP, vive en Texas, pero ya tiene su entrada legal. No sabe cuándo pedir asistencia legal. Honestamente, si tienen un caso súper simple, no tienen historial criminal serio, que sea fuera de tickets de tráfico, tickets simples, o que tengan entradas múltiples, and what was the rest of it? Criminal record,
Cargos criminal records, or any deportation
o
proceedings.
cualquier orden de deportación, ya sea cerrada, abierta, esos tres. Y también por si tienen información en su FOIA que no sea correcta también. En ese caso, pues sí, les sugerimos que pidan asistencia legal. Tenemos a Gloria Cárdenas, lo pueden encontrar en TikTok como The Immigration Queen. También a Charles Cook. Siempre vamos a recomendar a Charles Cook. Él fue el presidente de la Asociación de Abogados de Inmigración de todo el país hace unos años, y es profesor de leyes y super cool. Siempre lo vamos a recomendar. Si quieren si quieren llamarles o contactarlos para obtener asistencia legal, por favor, no duden en hacerlo. Pero esas serían las razones por las que sí recomendamos que sí pidan asistencia legal. Pero si es un caso, si su caso es súper simple, no tiene nada de eso, háganlo ustedes mismos. Es simple, nada más hay que ser un poquito detallados.
Josie solo da un poquito más de información aquí, que ya está en debate entre hacer el AOS hacia el hospital como por empleo o por AP, por supongo que se casó con alguien o a lo mejor tiene hijos ciudadanos, pero como habíamos comentado, Josie, si es por empleo no puede ser AOS, tiene que ser proceso consular, a lo menos que tenga la 245I. She cannot do employment AOS based through hospitals. She's wrote down that she's a nurse in another comment. Or so you can't do AOS through employment unless you can't do it unless you have 245I, so that would leave consular process. But if she's being petitioned by a spouse, she can do AOS even if her AP is recent. Doesn't matter if your AP was yesterday, you can submit your AOS application today. So as
Yeah.
long as you have it, you can send it. I will say though, Josie, two quick things. If you're a nurse, like I said, I see here that you posted you're a nurse. You can possibly have a reason to expedite your AOS processing so that it can get approved a lot faster. So nurses are one of those few categories where, because we're technically still under certain COVID um, needs with emergency departments and things like that, you can try to request an expedite due to being a nurse. I'm not quite sure how it'll go. You can definitely request an expedite of a possible combo card.
Mm-hmm.
Um, but if you're between employment and a spouse, I would suggest spouse because it's eligible for AOS. And also with a spouse, you can become a citizen within 3 years instead of 5. So that's my other reason. So Josie dice que es enfermera, si acaso eso lo ayuda con el proceso de AOS. Le aviso que por empleo no puede hacer AOS, tiene que ser 245I para hacer eso. Sería proceso consular. Pero si es que ella está cansada o tiene hijos ciudadanos o mayores de 21, sí puede hacer el AOS y posiblemente puede pedir que le hagan el caso un poco más rápido, dado que es enfermera, por lo menos que le den el permiso de trabajo y de viaje más rápido. Y también cuando uno saca la residencia casándose con un ciudadano, se puede conseguir la ciudadanía entre 3 años en vez de 5 como el resto de la gente que consigue la residencia. Voy a poner aquí, ese es el website. Gracias, Marisol. De que usted puede ir a conseguir el FOIA de CBP y de OBIM, www.securerelease.us. Va a estar ahí en el screen. Si no lo ven, siempre pueden ir a ver este video que va a estar en Facebook y ver en los comentarios, va a estar el de Marisol con ese sitio de web que necesita. That's the website for CBP and OBIM FOIAs. If you miss it now, it'll be in the comments, thanks to Marisol. So you can go ahead and just grab it from there, or you can always reach out back out to us and let us know. I'm going through here really quick. What's the first step to do AOS? My daughter's 18. I have AP, just taking notes. Thank you for the live. Thank you for coming to the live. First steps for AOS. If you're thinking of pre-filing, my suggestion for your first steps would be join our AOS Facebook group and read through our guides. Go to our guides, read through the guides, and then check out the files and look at the cover letters. And then the cover letters will specify how you organize your AOS packet, as well as it'll give you examples of what supporting evidence you can submit. So that would be my first suggestion. Read our guides, read our files, and then join in on the discussion in the Facebook group. If there's anything you're not too sure of, post a question. Before you post your question, try searching up keywords of your question, because most likely your question has already been answered in the group itself. But if it's something new, or if you can't find it in our group by searching, you can always ask the question and we'll be more than happy to help out. Your daughter does need to be 21 though. But start prepping now, because you can prep everything and have it all ready. And then the minute your daughter turns 21, maybe
Yep.
the next day, you can mail out your AOS document and get it everything processed as quickly as possible. Ana pregunta cuáles son los pasos de AOS, que su hija aún tiene 18, pero que ya hizo la P. yo le digo que para mí los primeros pasos sería añadirse al grupo y leer las guías y los files que tenemos, las cartas, los cover letters que tenemos para orientarse con el proceso y cuáles son los formularios. Y ya después de eso es simplemente preparar. Si tiene preguntas, lo puede hacer en el grupo o también puede usar la barra de búsqueda y buscar sobre su pregunta. Y si no está ahí, los pregunta y nosotros le ayudamos. Pero que no se olvide que la hija tiene que tener 21. Pero prepare su paquete de AOS y ahí el día que su hija cumpla 21, el siguiente día lo puede mandar. No tiene que esperar un cierto tipo de tiempo ni nada, puede ser el mismo día que su hija cumpla 21. Um, Maria says hi. Hi, Maria. Thank you. Appreciate you always.
Thank you. All right, last one. Dice Carol. Hola muchachas, ya mandé el email que me sugeriste, Natalie. I hope you guys can help me with my package. Ya estoy casi lista. Mañana tenemos el examen médico y más tardar el martes quiero mandar el paquete.
Oh, Carol, bien preparada. Felicidades, Carol, que tiene todo listo. Le vamos a avisar ahí al equipo de administración que ponga ojo para el email y le avisamos cómo puede hacer una cita para que le revisemos su paquete, porque se lo podemos revisar. Nos podemos preparar, pero se lo podemos revisar. Pero qué bueno que tenga su examen médico. No se le olvide llevar los comprobantes de sus vacunas. Y ya cuando tenga todo listo, le enviamos toda la buena suerte para que su caso sea aprobado lo más rápido posible. Carol says she sent the email. She hopes we can help her with her package. She's ready to go. She has her medical exam tomorrow and then wants to send her packet on Tuesday as fast as possible. So, congratulations, Carol, on being so prepared. And we wish you the best with your packet so it can be approved as quickly as possible. We do have appointments for AOS reviews, which is what Carol is talking about here. So, if you have your AOS packet prepped and ready to go, and you like an extra set of eyes on it, we do offer AOS reviews. We'll reach back out to Carol so she can schedule one. But that is something that we offer. The D2G volunteers will give you instructions as to how we go about that. But we can review your AOS packet if you feel like you need another set of eyes. Completely optional, guys. It's not something you need to do, but we do offer it for those of you that feel a little more comfortable with that. I think that's it. Oh, we
Yes,
got one last
last one. Yeah,
Okay,
one.
last one.
Dice Maria Arteaga. How long is the AOS with a resident instead of a U.S. citizen if you can't get AP or any proof of legal entry?
So, unfortunately, first of all, I'm thinking you're saying if your spouse is a resident instead of a U.S. citizen. If your spouse is a resident, you're not eligible for AOS. So you definitely, if your spouse is a resident, I would push your spouse to become a citizen, so that they can help you out and do AOS all within the United States, which is safer, cheaper, and faster.
Mm-hmm.
So definitely have your spouse fill out that citizenship form. It's also one that's not too difficult. A lot of people do it on their own. It's a lot of personal information. The sooner they get that done, the sooner they can have their swearing in.
Mm-hmm.
But in the meantime, prep your AOS package. Why? Because the minute that your spouse has their US citizenship certificate of naturalization in hand, you get a copy of it, you put down the numbers from that certificate in your forms, and you send out your AOS packet. So again, it's also about being prepared. Now, in your case, you said if you can't get AP or any proof of legal entry, you do need legal entry in order to get AOS done. That's one of the requirements. So if you're not eligible for AP, I'm not sure if this person has DACA or something else that allows them to apply for AP. If your status that you currently have allows you for AP, but you just don't think you're eligible, like you don't have a reason that you can apply for it, join us on our AP group. We'll find you a reason. We'll
Mm-hmm.
talk you through it. We'll figure out what family members you have, what's your job situation, what's your family situation, and most times, like 9 out of 10, we can find a reason, an official reason that USCIS will determine that is approvable for AP.
Yeah.
Um, Now, if you say proof of legal entry, if you came legally to the US, but you lost your I-94 or you lost your proof of it, you can FOIA for that information. Because I know I have a few people in the groups that have said, "Oh no, I came on a visa, but this was like back in '98 and I don't have that paper anymore." You can FOIA for it. It might take a couple months for them to get back to you with that information, but you can FOIA it and they'll get it to you. I personally had to do that for my grandmother. She came to the US back in 1998 and she unfortunately lost her passport and her I-94. But we were able to find it through a FOIA with her name, her date of birth, and information about when she took the flight, what airline she used, and what airport she came in through. And they were able to find it, and they gave us the documents for it. So you can definitely get that if that's what's going on here. En español, y ya de luego nos vamos porque la última pregunta. Um, Pregunta si acaso es más alargado el proceso AOS con un residente en vez con un ciudadano. So, la primera parte de esa pregunta: no es elegible para AOS si su pareja es residente y no es ciudadano. Si su pareja o hijo es residente, presiónelos de que se hagan ciudadano, porque hacerse ciudadano ahí ya sí le pueden ayudar. En términos de AP o comprobante de entrada legal, si es que usted tiene un estatus que sí permite AP, pero no sabe si tiene una razón por cual el AP sería aprobado, júntese con nuestro grupo de AP, y comuníquese con nosotros y le encontramos la razón. 9 veces de 10, mucha gente piensa que no tiene razón, pero si no tiene que ser algo severo como un familiar urgente que esté con un estado de salud muy delicado, puede ser algo simple. Pero avísenos si es que usted tiene DACA o TPS o algo que le ayude, que le deje aplicar para la AP y vemos si le podemos encontrar una manera de hacerlo. Ahora, si no tiene DACA o algo así para la AP, pero mencionó aquí comprobante de entrada legal. Si es que usted entró legalmente a los Estados Unidos, pero hace muchos años y a lo mejor perdió el I-94, que es el comprobante, o perdió el pasaporte, esa información también se puede conseguir con un FOIA de CPB. So, avísenos también si esa es la situación, y le explicamos un poquito más en detalle en el grupo cómo es que usted puede pedir ese FOIA. Creo que eso ya son todas las preguntas. Ya estamos aquí bastante tiempo con ustedes, ya casi 2 horas, o le vamos a dejar ir para que vayan a estar con sus familiares o terminen el resto de su domingo. So we are going to sign off, guys. Thank you for coming to the live. Thank you for all your questions. We've been here a little bit over 2 hours. So if you do have any more questions, post it in the comments. Reach out to us on our Facebook pages. We'll be more than happy to help. Thank
Yes.
you, Marisol, for being here
Thank you,
and
Nana.
answering all the questions. But that is it for today. Thank you, everyone. We hope you have a great rest of your Sunday. If this is something that you enjoyed and having these lives on the weekend was best, please let us know so that we know if we need to schedule another one on a different weekend.
Please.
Thank you so much, everyone.
Bye.
Maddie.